Well, good afternoon, everybody, and thank you for inviting me to do this. Now, some of you in your sign-up said that you don't know much about data protection already. Just in case there are people who are starting from that point of view, I'm going to start off by saying a little bit about, just go over the key things about data protection that are going to be important in the rest of the discussion. If you know this already, my apologies. But I'm sure you won't mind bringing everybody else up to speed. This is your small print for today. I'm not a lawyer, so I can't give you legal advice, but I am doing my best to understand GDPR and all the effects of Brexit on that. Just to recap right from the beginning, data protection, it's called data protection. It's not about protecting data, it's about protecting people. And it doesn't matter who these people are, hold information about them, data protection applies. And our main responsibilities are then to make sure that we keep the information in the right hands and to have good quality data so that we don't make the wrong decision about people or let them down in some way. Data protection is also about the fact that now that we have everybody's data on computer, we can do lots of things with it. And sometimes people don't like us doing these things. And so there's a whole issue with transparency and choice. We don't always have to give people a choice, but we may have to give them one. And that will come up later on in the talk. And thirdly, people have rights, and you're probably familiar with the right of subject access, where people can see the information that we hold about them. People have the right to opt out of direct marketing. There's a load of others. We're not going to talk about those today particularly, but people have much more control over what we can do with their data than they used to before GDPR came in. Excuse me. So we've had GDPR in force for 2.5 years now. You're probably familiar with it. Just to go over the basics. It applies to personal data. So this is any information that we hold about identifiable living individuals. So if we have information about people stored in any way on our computer, on paper or whatever, then data protection applies. And if we have it, by definition, we're processing it, because processing covers anything that we do with information, from collecting it, storing it, using it, changing it, sharing it, all the way through to deleting it. And if we process personal data, that makes us a data controller. Now, when I say us, that's deliberate, because the data controller is usually a collective responsibility. You'll see the definition here is that it's a natural or legal person who determine the purposes and means of the processing of personal data. So if your organisation has information about individuals and you use it or store it or do whatever with it, and it's your organisation making the decisions, then your organisation is a data controller. You may be in a situation where you collaborate with other organisations. And in this situation, you could very well be joint controllers. And your responsibility here is to make sure that you know who is responsible for what. You can't just blame each other if something goes wrong. You must set out an agreement between you transparently, you'll see the word there, to explain who's going to do what in order to comply with data protection. And then the other situation where you're involved with other organisations is where you pay someone else, usually an organisation, but it could be an individual, to do something on your behalf. GDPR says that if they are handling personal data for you, you must have a contract which meets particular requirements. If they don't do what you tell them, they can be directly liable, but if they follow your instructions, you are responsible for what they do. And the reason why that is important for today's session is that if you use a cloud provider to host your database, to run events for you, to do surveys for you, to manage your email lists, you will probably recognize quite a lot of the commercial providers that I'm referencing here without giving their names. anybody that you use to do the work for you is going to be a processor, and you have to have a proper contract and arrangement with them to make sure that they do what you want them to do so that they don't let you down. And we will come back to this concept of processors later on. But it is important to distinguish between controller, joint controller, and processor, because you need to know who's responsible for what. So that's the platform, that's the basis. We work out who's responsible. Now, once you know that you're responsible, what are you responsible for? The two main pillars of data protection compliance are that everything you do must have a lawful basis, and everything you do must comply with the principles. Those of you who are familiar with it will probably know what I'm talking about here. One of the things that sometimes trips people up is that there are 6 of each, 6 lawful bases, 6 principles, but the rules are different. With a lawful basis, you have to have 1 of the 6. With the principles, you have to comply with all 6 all the time. So we'll just have a quick look at those, but again, because they're relevant in the rest of the discussion. So here are the 6 lawful bases, and you will see that consent is one of them. When GDPR was being agreed, there was a lot of fuss from people outside the process saying, oh, it's going to be dreadful because we're going to have to get consent for everything. But that's not true. There are 6. These are all equal. They're not in order of preference. Consent is one of them, but you could even easily meet one of the others, provided you can show that what you're doing is necessary. All of these 5 have the word necessary in their definition. I'm going to go through these at all, but I am going to say a little bit about consent, because that will come up again when we talk about Brexit and transfers abroad. So GDPR made it clear that consent must be a genuine choice by the individual. So the definition here in Article 4 of GDPR is that it has to be freely given, specific, informed, and unambiguous, and that people have to give a statement or take a clear affirmative action. So consent has to be genuine, and you have to be able to show that people have actively given consent. So these examples that they gave in recital 32, silence, pre-ticked boxes, or inactivity is not consent. You can never assume that somebody has given you consent. You have to be able to show it. You have to present it clearly to them. They can withdraw it as well. So if you're basing your processing on consent, you have to bear in mind that people might say, no, I withdraw my consent, and then you have to stop doing whatever you're doing with consent. And you can't make consent conditional on a contract. So consent, again, it's all hammering home the fact that consent has to be a genuine choice. You also have to keep a record to show that you've got consent, because you have to be able to demonstrate it if should push come to shove. So consent, important concept in GDPR. Lots of things we can do without consent, so it's not something to worry about. But if you are going to rely on consent, you have to do it properly. I'm not going to talk about the other lawful bases here, because that would lead us down all sorts of alleys that we haven't got time to talk about now. We'll have a quick look at the principles. You have to be fair and legal. You have to have limited purposes. You have to only keep the information that you need. You have to be accurate and up to date, not held longer than necessary. And you have to have appropriate security. It's the first principle that is going to exercise our minds a little bit later on, because it says that personal data should be lawful, fair, and transparent. And when GDPR came in, it was the transparency that made the biggest change in terms of what you have to tell people about what you're doing. So this is my slide on transparency. The blue bits is what used to be the situation under the old data protection. Red bits were introduced by GDPR. So you have to tell people your lawful basis. You have to spell out your legitimate interest and the right to withdraw consent. But the key thing is the other line here, that you have to tell them about anybody else who's going to receive the data, including overseas transfers. I mean, there's a whole load of other stuff you have to tell them, but we're not going to go into those now. It's the overseas transfers bit that is the important bit for today's session. The next three principles: you have to have good quality data. So it's got to be the right information for the purpose. You have to make sure that it's accurate and kept up to date where necessary, and you have to not keep it any longer than necessary. Those aren't going to come into today's session particularly. And then the final principle is the security one, which says that you have to protect against integrity. You have to aim at integrity, which means protecting against accidental loss, destruction, or damage. And you have to aim at confidentiality, which means preventing unauthorized or unlawful processing. The measures you take must be appropriate, and they must be technical and organizational. And if you don't have the data in the first place, then you don't have to protect it. So that helps you with security as well. So again, I'm not going to talk about security, but it's just worth bearing in mind that it is one of your main responsibilities. So those are the elements of GDPR. And then on top of that, there's a whole load of things that we have to do in order to be compliant. And one of those is to be aware of our responsibilities when we transfer information abroad. And that's what we're mostly going to be talking about in the second half of this presentation. So we have GDPR because it's an EU regulation, and when it was passed in 2016, we were in the EU. When it came into force in 2018, we were in the EU. So there's no question about it. GDPR applied in the UK from the 25th of May 2018, and we've now had it for 2.5 years. And most people are getting quite familiar with it. So when we left the EU, we entered a transition period, and everything about the EU that applied while we were in it continued to apply while we were in the transition period. So GDPR just carried on the same. And then during the transition period, the UK government made provisions for when we finally leave the EU, which will be on the 31st of December this year at 11 p.m. And of course, then GDPR being an EU regulation won't apply anymore. But in a piece of legislation whose title is so long that I can't even remember what it's called, they made provisions for what happens with data protection after we leave the EU. And the main thing that they did was they said GDPR will carry on almost as it is at the moment. So the fundamentals that I've just been talking about, the 6 lawful bases, the 6 data protection principles, they will carry on unchanged. They've made lots of minor changes to GDPR, but almost all of them are about taking out references to EU institutions, which no longer will be relevant in the UK. And a couple of very minor adjustments to it. But basically, the fundamentals of GDPR stay exactly the same, and everything that we've learned so far don't change. The one thing that will be significantly affected is transfers of data between the UK and other countries. Now, as you'll see in a minute, transfers to the EU and to most other countries will remain unaffected. Transfers from the EU are where difficulties might arise, and that, I think, for most people is likely to be the most significant effect of leaving the EU, leaving the transition period in 31st of December. of course, once we're not subject to GDPR, we could change our rules. Our government, we've taken back control. Our government could change our rules. There have been suggestions that one of the things that their national data strategy sets out, which they published in about June this year, they may be tempted to water down our data protection so that we're in a stronger position to exchange data with other countries without too much restrictions. So there may be some changes there, but that's only a rumour. So keep an eye out for that, but at the moment we don't have to worry about it. So after we leave, after the end of transition period, the EU will be a foreign area. Now, at the moment, all transfers within the European Economic Area are defined as being okay. So if we want to exchange information with an organisation in France, that's no different from exchanging information with an organisation in Nottingham or Glasgow or somewhere like that. So the European Economic Area is the EU, which will now have 27 members, and these three, Norway, Iceland and Liechtenstein, which are basically they sign up to the same things as the EU. So within the EU, transfers are pretty much no different from transfers within the UK. Transfers to other countries are also possible if the EU or the UK now has made a decision on the adequacy of that country's data protection provisions. So in the legislation, which I was talking about, the UK legislation, which changed the GDPR, one of the things they said was that they would accept all of the EU's decisions on adequacy that have been already made. So these countries, Andorra, Argentina, Guernsey, Isle of Man, Israel, Jersey, New Zealand, Switzerland, Uruguay, they have data protection legislation. It's very similar to ours, and therefore they're okay. So there is no restriction on transfers to those countries. In the legislation, the UK decided that Gibraltar is okay. I don't know why the EU hasn't made a decision on adequacy, because Gibraltar does have data protection legislation and it's pretty similar to ours. So I don't really understand. It may be something to do with Spain holding things up because they always stick their oar in when they can over Gibraltar. But apart from that, I don't know why Gibraltar isn't okay, but the UK says it is anyway. Then there are decisions on adequacy about Canada and Japan, but they're only partial. So in the case of Canada, it only applies to commercial organisations. In Japan, it only applies to non-governmental organisations. But given that that means that the kind of organisation we might want to share data with probably get covered there. USA, complicated. Going to talk about that in a minute. So these countries, no issue up to now. And for transferring information from the UK to these countries abroad, that's not going to change. So if you want to send information to these countries, no problem. It's no different from sending it from exchanging it to other organisations within the UK. The difficult areas is everywhere else. Now, the USA, they have a kind of an approach that's completely different from the Europeans, and they have always said that they don't want to have national data protection legislation. They have some state legislation in California and other places similar to ours, but the USA as a whole doesn't have national legislation on data protection. So you may remember they set up this thing called Safe Harbor, and an Austrian guy called Max Schrems took it to the European Court, and it was thrown out as being not safe enough at all. So they replaced it with something called Privacy Shield, and Max Schrems took that to court, and that got thrown out as being not adequate as well. In a decision, a recent decision, July this year, the European Court of Justice said no, Privacy Shield doesn't provide adequate protection because it doesn't prevent the US government from interfering with the data, having access to the data. So Privacy Shield is kind of been thrown out. Now, in all the countries where there isn't an adequacy decision, and now that includes the USA, the EU said, well, there's an option. You can have a contract with the recipient organisation, and we will come up with standard contractual clauses. And if you have those clauses in your contract with the recipient organisation, then the transfer is okay, because that will guarantee that the data is just as protected when it goes abroad as it is within the EU. And there's an equivalent to the standard contractual clauses. If the transfer is within two parts of an organisation, you can have something called binding corporate rules, which gives you the same permission. You can still transfer the information because the recipient part of your organisation is subject to the rules, and so the data stays protected. If you're not in a position to have those standard contractual clauses or binding corporate rules, there are specified situations where a transfer abroad is still okay, and if those don't apply, there are some other options, which I'm going to show you in a minute. But it all starts to get very, very complicated. So the specified situations where transfer is permitted is, here we are back with consent. So we can go to the individual and say, we want to transfer your data abroad. Are you happy with that? But we have to be prepared for them to say no. So you can't use that as your blanket thing. If you're transferring data, your whole membership abroad, you can't base that on consent, because if anybody says no, you're scuppered. But for an individual data going abroad, that's not a problem. You can also transfer it without consent if it's necessary for the performance of a contract. Now, this applies to tour companies. Yeah, you're going to, I don't know, South Africa. Tour company wants to tell the hotel that you've booked. Of course, they have to transfer your personal data to South Africa, because otherwise they can't deliver the contract. So you can do that without consent. And the next one is slightly more complicated, but if there's a contract in your interests, but it's someone else's data that you can transfer. I haven't gone into that in a lot of detail because I don't really understand it. The next ones are probably not going to apply very often. If it's necessary because of public interest, necessary in connection with legal claims, necessary to protect vital interests, and the data subject can't give consent, but that really means life or death situations. It doesn't just mean going on holiday stuff. Or if it's being transferred from a public register. So there's various things where the transfer abroad is permitted, but often you're going to be looking at the top two. It's either going to be based on consent or it's going to be necessary for the contract. Even if you don't meet any of those, you can still make the transfer if it's not repetitive, concerns a limited number of data subjects, and is necessary in your legitimate interests. The key thing I want to point out here is the not repetitive bit. And also the limited number of data subjects. The legitimate interest, probably we could meet that, but it's not repetitive and a limited number. We don't know what a limited number is, but there isn't any guidance on that. But basically, this is kind of one-off and occasional things rather than standard practice. So sorry, I jumped 2 slides. So those are the rules. Now, what does that mean when after the end of the transition period? One of the things that is likely to occur is that you have some of your personal data that you hold might be on the computer in your office, but quite a lot of it these days is going to be in the cloud. And what counts here is where is the cloud provider storing your data? Because it's the jurisdiction that the data is sitting in that counts. It's not the jurisdiction where the individual lives. It's the jurisdiction of where the data is that matters. So you might have information on French people who live in England. That's not a problem from this point of view, because that's just subject to our normal rules. But if you have information on English people, which is stored in France, then you're transferring it abroad and the rules apply. So if your cloud provider is based in the EU, transferring the data to them isn't a problem, because the UK has said that the EU is acceptable. But getting it out, you do all the time. I mean, the data's going backwards and forwards all the time. Transferring it out isn't a problem. Getting it back is a problem unless and until the EU makes an adequacy decision. Now, they should make an adequacy decision on our GDPR, because GDPR is almost identical to the EU GDPR. So there's no obvious reason why we wouldn't get a positive adequacy decision. You know, if we had the goodwill of the EU behind it, they could probably make it tomorrow. Possibly they're going to try and prove a point and not make their adequacy decision in a hurry. Who knows? But at the moment, we don't have one. If that remains the situation, as long as that remains the situation, that the EU has not decided that our data protection is okay, then any transfer from the EU back to the UK should be based on standard contractual clauses. And that should be agreed between you and the recipient organisation. We'll come on to the practical implications of this in a minute. If the cloud provider is based overseas in a country where there's an adequacy decision, again, the data transfer from the UK, not a problem. Data transfer back to the UK, well, it's probably okay, but it may depend on their rules. Do they allow data to be sent to the UK? Have they decided that the UK is adequate? So if not, if their rules don't allow it, then again, you might be looking at standard contractual clauses. If the cloud provider is based overseas and there hasn't been an adequacy decision, then the transfer from the UK must use standard contractual clauses, because otherwise the data wouldn't be protected. And data transfer back would depend on the rules of that country, but again, you may be looking at standard contractual clauses. So in a lot of situations, if your data is being held and processed by a cloud provider, and the data is overseas, in a lot of cases, there is an issue about getting the transfer at least in one direction or the other on standard contractual clauses. Scenario 2, your data subjects are abroad. If they're in the EU, then the data transfer from the EU to the UK is probably okay, because they probably consent to it and they know what they're doing, but you would have to make sure that they're happy with that. But for you transferring the data back to them, no problem. If the overseas country has an adequacy decision, data transfer to the UK depends on their rules, but given that the adequacy means that their data protection is similar to ours, then it's probably okay. And again, no problem. And if there's no adequacy decision, the UK, you would probably be looking at consent or legitimate interest for contract or something like that, and probably the same in the other direction. So if the data subjects are abroad, there's some minor issues, but I don't think the problem is anything like as big as the question about using cloud providers where your data goes in bulk to a country outside the UK. Now, you will have noticed probably that there was a bit of a kerfuffle a year or two ago where the name of the organisation has escaped me at the moment. A company, a large internet company, I can't remember which one, announced that they were going to move all their data to Ireland if it related to the EU, so that it wouldn't raise any difficulties with transferring the data outside the EU. Now, of course, that was fine while the UK was part of the EU, but now that it's not, then that puts us back in the situation where it could cause us a problem. The fly in the ointment with all of this, I said that a lot of it could be based on standard contractual clauses. Well, the same European Court of Justice decided that the privacy shield wasn't any good, also looked at standard contractual clauses and said, well, they're probably not any good either, because they don't prevent the US government from interfering with our data. So if your cloud provider is in the USA and the data is in the USA, you're probably scuppered in theory. But this is the case for a lot of data. What are we going to do about it? Nobody knows. The decision was only taken a few months ago and nobody has really sorted out what's going to happen. They might be waiting to see if there's a change of leadership in the United States. You never know. That might bring about some scope for negotiations. But at the moment, it's all up in the air because the lawyers say that the clauses don't work. The legislation says they're the only option. What are we going to do? So, so everybody who's transferring data outside the EU has this problem at the moment, and it'll probably continue to apply to us even though we're not in the EU, because I strongly suspect that we're going to maintain quite a lot of parity with the EU as things go on. So, where does all this leave us? Well, for most of what we do, most of the time, it doesn't change things significantly because we still have GDPR and it's almost identical in all practical senses. It's identical to what we've been doing. So most of what we do won't have to change and shouldn't change because, you know, we can't say, oh, GDPR doesn't apply anymore. It does. It's just the UK GDPR. However, if we're storing data outside the UK, we have to make sure that we know where it is. And I know a lot of organisations have been quite diligent in making sure that their data is stored within the EU up to now, just to avoid any of these problems that we were talking about. Now, with leaving the EU, you are probably looking at, can we be guaranteed that our data isn't leaving the UK? And that is more of a tall order because these big internet companies don't want to make special provision for the UK, I expect. But it's worth finding out. They might give you the option of saying that you don't want your data to leave the UK, in which case you're fine. That I would go with that option. There are providers who are getting ahead of the game and they are incorporating standard contractual clauses into their contract. If the standard contractual clauses gets ruled out, that's going to blow that idea. And of course, with the USA, we've already been told that the standard contractual clauses are no good. But if in the meantime, if your provider is in the EU and they've put the standard contractual clauses into their contract, then you're probably okay. If you make regular transfers, then you need to ensure that they're acceptable. And you need to think about a procedure that if you occasionally transfer personal data outside the UK, you need to just make sure that it's acceptable. But I wouldn't expect those last two to apply to many people or be difficult to resolve. The main problem, I think, is going to be with cloud providers. And, you know, I'm trying to put the wind up here because I think it could matter. But on the other hand, you're not the only ones in this boat. So it's not as though someone's going to come knocking on your door suddenly and say, okay, where's your data? Oh God, it's in Germany. Where's your standard contractual clauses? You haven't got any, therefore you're in trouble. I don't think that's going to happen, because the Information Commissioner has basically said, well, just carry on as we are while we sort things out. But theoretically, and certainly in the long run, until we get an adequacy decision, there might be an issue with this. Now, before I go, because I'm going to leave time for questions, I just want to give you an advert. Sorry about that. My fourth edition of my book on data protection, coming out in January. And sorry, I need to. Sorry about that. So anyway, I just want to tell you about that. And here's my email address. I mean, Kate, I think, will field any questions that you send in to her, but I'm happy for you to take questions by email, and I'll deal with them as soon as I can. So that's the end of my presentation. I wanted to leave 10 minutes or so for questions, discussion, anything that people have. So I'll stop sharing my screen, I think.